Court.2 is now session. The objections tonight.
Good morning, everyone. You can all be seated. We're on record in State versus Davis, C-377-407. Welcome back, everybody. Anything we need to address outside the presence?
Your Honor, I do have some concern with regards to the state's current presentation of evidence in this case.
Okay.
There was some discussion, I believe, that was on recording. That was something that I did not believe should have been included. Some prior bad act that was in the first, I don't know, maybe 5 or 6 minutes of the recording that we listened to on Friday. I did not make an objection to that particular point because I was trying to figure out whether it came in under some motion practice prior, and I don't believe it does.
And specifically, what bad act is that?
Is that Mr. Davis is talking specifically about criminal history, and he had mentioned something along the lines that he was involved in a shooting, and that and it was also because of drugs. We've always known about drugs as in criminal history, but with regards to his reference to a shooting, I think it's highly prejudicial in this case. And I don't know where it's at in there. I was trying to figure out with my people over the weekend where it was exactly, but we don't have this exact recording.
Okay. So in my motion regarding the bad acts and regarding essentially all of the evidence that was going to be admitted in this case, there was a caveat that there would be certain things that would be excluded, that could be redacted out. Was this something you were familiar with in your previous listenings, or it just kind of took you by surprise when you heard it this time?
Well, we don't have the proposed redacted version of this.
There is no redaction done to this whatsoever. The request made to redact it, but our motion specifically addressed that his first criminal conviction was a misdemeanor for shooting into the occupied structure.
Can I finish with Mr. Samft real quick,
Sure.
and then I'll turn to you, Mr. Giacomo. Mr. Samft, go. You may finish.
Oh no, I was listening to Mr. Giacomo. So I mean, to me,
Okay.
the bigger issue is that we have this recording now. I mean, obviously, if there's things in here that is potentially going to be a problem, there would be, at least with the state, some effort to reach out to me and say, hey, here are the things that we think that still falls under the purview of what the court order was in this case, and maybe there's some things in here you want to discuss. I would think that would have been a discussion prior to the publication of it. I just presumed that what we were hearing up on with this particular witness on Friday was the stuff that we had already heard. The problem is, like I said, there's a reference to a shooting in here, there's a reference to another, I can't remember what the other act is that's in there, but once again, it goes back to the fact that there was some motion practice done on this, and I agree with the court. The other part of the problem is that, we've had reference to the Biggie Smalls murder. The state in their own motion practice had indicated that they weren't going to, that the Biggie Smalls murder had nothing to do with the Tupac investigation. And to me,
I think with Mr. Dwayne Davis had no involvement in the Biggie Smalls. And we've admonished the jury that there is no indication that he has anything to do with that at this point. But ultimately, the nexus of this investigation was such that they were investigated together, for better or for worse.
Right. And I mean, we could sit here and talk word all day with that jury waiting outside, but I think what we're proposing the court to do, what I would propose the court to do, is just have some type of limiting instruction to the jury, in indicating to them you may be hearing other things that are not the focus of this particular investigation of Tupac's murder, something along those lines, just a limiting instruction.
Sure. Mr. Giacomo, do you have an objection to the limiting instruction?
No, I actually think before every witness, maybe you just read that Tavares instruction to them
Okay.
each time.
So just to remedy what we're talking about now, I'll have Mr. Samft propose a limiting instruction, and then from here on out, given the party's dual request, I'll read the Tavares instruction, unless it's a witness that has nothing to do with, if it were, for example, the gentleman who'd taken the photo, he wouldn't have anything to do with the bad acts that we wouldn't have to read. But if it were anybody else, probably law enforcement at this point,
Yeah.
I can read it.
Yes, Judge, and that, just so that there's complete candor to the court, we did a motion on his prior shooting. It sounds like to me it's not real clear. We didn't do a motion on his 2015 conviction. I didn't realize until it was rolling and you hear it's actually being spoken that he does reference some police contact in 2015. And I do realize he was convicted of that. I didn't know or recognize that was in there. If the court wants to, since we're past that portion where he talks about it, we can have somebody redact the audio so that the one that goes back to the jury does remove the reference to the 2015 conviction. Because he talks about the last time I was in the feds or the last time I was in prison, and then he mentions 2015.
Okay.
And that has to do with an event that's completely unrelated to our investigation. I just didn't realize, I didn't tie those two together until I heard the audio being played with the transcript.
Okay. So we'll have that redacted when it does go back in case they spend more time with it. Mr. Samft, what is the proposed instruction that you would like at this time for me to read to the jury when they walk in?
You're asking me to put it together?
Yeah. That's your job.
I
That's
know,
what you're good at.
it is my job. Here's my biggest people.
Okay,
Your Honor,
I'll let Colleen make a proposal.
Yeah.
Your Honor, I think it'd be something along.
I'm gonna let him propose it.
Yeah, let me propose it.
All right, then we can have some discussions about what it actually is.
Okay, let him propose it. You can object, but I think it's cleaner for the record if he proposes it.
I don't know that it matters for Tavares, but okay.
Huh?
I don't think it matters for the purposes of Tavares, but okay.
This isn't a Tavares instruction. The Tavares instruction's already been determined because this isn't something that's being let in for the purposes that I let in bad acts. This is something that they're asking just to disregard.
That's only the 2015.
Yeah.
The
Correct.
shooting should still come in because the court ruled upon that.
Yeah, that's what I thought we were talking about.
So what is the shooting is there for credibility of the statements of defendant, motive, and identity?
Yes.
In his book, he starts off with, my first criminal conviction is shooting into an occupied house, and describes the event. That comes in. What shouldn't come in, and if he wants a limiting instruction on, is 2015. I don't know if they would want a limiting instruction since we're going to redact the audio before the jury gets it. We'll also redact the transcript before the jury gets it. So I don't know if he wants to draw attention because they may not have caught.
I'm gonna let them talk and then I'll let you guys weigh in.
I do have one other further matter, Your Honor.
Okay.
I'm done with this particular issue. The other issue is this, with regards to Mr. Dorsey's testimony, we have a record from Detective Mock who interviews Mr. Dorsey prior to his testimony. His testimony, though, on the stand really made things a little bit more easier to understand in terms of how his relation is with this case. In essence, what happens is that BET is asked by the district attorney's office to produce documents. Maybe it goes through MOG. Maybe MOG is the one who does it. But in either event, BET says, okay, here's what we're going to produce. And they produce the actual finished product as their production.
Right.
They don't introduce B-rolls. They don't do anything other than that. And they basically said, that's all we've got. I think Mr. Diaz or Rios or whatever his name was prior to this had said something along the same lines that, hey, this is just how they do. The problem with what we're doing now is this. Mr. Dorsey gets up there and testifies and he says, look, my job, from what I understand, was to listen in to the interview that's being conducted between Mr. Davis and the interviewer, which, whoever that person is. And he's supposed to be there to really sort of make sure that Mr. Davis is not lying or saying something that's off from what he understands the 2008 proper session to be, the recording. Here's the problem with it. At the end of what he does, and what he's proposed now, what the state is now using, is surreptitious recordings in between the official recordings by BET. Now, what does that mean? That means that while Mr. Davis is sitting in that room, he's sitting in that room with the interviewer, and at some point he's going to be asking for breaks. He's going to be asking for time to talk to somebody else.
Okay.
Which we understand it to be Wayne Higgins, his attorney. Those conversations are not hot mic conversations. They are conversations between attorney and client, and there is a reasonable expectation of privacy there because of the fact that it's done off camera, because BET does not record it. And on top of it too, that as that's happening, they're talking in a tone, they're not yelling and screaming it out loud, but they're talking in a tone to say, hey, what do we do here, whatever the issues are. I think those parts of this recording that Mr. Dorsey had done, I think those are parts that need to be included from the jury's understanding, because here's the thing. I understand he's not a state actor. I understand that it doesn't fall under this idea of, hey, well, he wasn't ordered by a detective to do that, and Dupree is definitely not a detective at this particular point. However, it is still a crime in California to record someone's conversations that they believe is private. Regardless of if we're in a room and having a conversation, if I'm having a conversation with this individual sitting right next to me and I believe that is private, under California law, that is still illegally obtained material.
But ultimately, the remedy for a private actor acting in a nefarious, illegal, whatever you want to call it way is not exclusion against the state because the state's not the actor doing that. So that was sort of my comment when it was brought up that way. I think the attorney-client privilege argument is definitely more interesting and is new. Or any final word on that before I turn to Mr. DiGiacomo?
Well, I mean, because here's the issue that we have. Right now, what we have is an individual who basically takes his iPhone out, plugs it down on a speaker next to where he's at. He's hiding in a room to avoid detection by Mr. Davis, and he's recording the entire time. You hear other people communicating or having some type of discussion on top of his recording, which means that it's done openly in front of his mic or whatever he's at. He doesn't see a screen or monitor. He doesn't know what is being recorded or not. He just records the whole thing. The concern that I have with it is right now, as we're watching and listening to what's being played by the state, we don't see where exactly it is that they're going to bring in the parts that are not in the transcripts that we have from the recording. That's the official BET operating versus the stuff that they have that would have the additional thing on top of it, the surreptitious recording by Mr. Dorsey.
Okay. State.
Two things. Mr. Dorsey had a transcript of his recordings that has been provided to the defense.
Okay.
And there's a transcript of the official BET recordings, which, if you notice while listening to it, even the BET transcripts does not pick up background conversations or transcribe background conversations between other people when Mr. Diaz is asking questions.
Okay.
Mr. Dorsey will testify, because I specifically had asked him about the attorney-client thing. He will testify at no point in time when Mr. Davis is talking to Mr. Higgins, is there not a third party present from E1 Entertainment? So there is no privileged communication that occurs between Mr. Davis and his attorney. Even at one point, you're going to hear Mr. Davis say, hey, hold on, this is a hot mic.
Let's bring him in and do a short evidentiary hearing then on that issue of attorney-client privilege.
Sure.
Okay.
I assume he's back there.
We'll have Mr. Dorsey come in real quick. We'll have him re-sworn, and then we'll just proceed on this limited issue outside the presence, and then ultimately I'll make a determination. I understand it's your proffer, but that's what he's going to say, but I'd rather have it fleshed out. Bring in Mr. Dorsey, just Mr. Dorsey, no jurors. No jurors yet. Okay, Mr. Dorsey, we're going to have you sworn real quick.
Raise your hand. You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated. May I have you state and spell your first and last name for the record?
Yes, it's Michael Dorsey, MichaelDorsey.
All right, thanks for coming back, Mr. Dorsey. I hope you had a good weekend. We just needed to do a quick outside the presence sort of hearing so I can determine the legality of some things that are coming in, okay? Or not, potentially not coming in. So I'll let Mr. DiGiacomo ask some questions about the issue brought up.
Mr. Dorsey, I know there's times on this recording where you capture conversations that involve the defendant and Wayne Higgins.
Yes.
During those conversations, were they ever alone in a room having a conversation? Was there always a third party present?
I believe they were always in the studio, and there are, I think most of the time you have to hear Mario talking with them. It's like a three-way conversation. So I understand like how privilege works. to some extent. And it sounded to me like always he was still in the studio, didn't go outside into a hallway. And again, you can hear Wayne Higgins talking with him.
And not just Mario Diaz. Isn't there a number of people
Yes.
to do this production that have to be in that room?
Correct. There would have been another producer. There's the sound recordist. There's at least one videographer. There's probably at least a lighting person in there. There's at least a good half dozen people in that room with them.
And at one point, does Mr. Davis make some comment about, hey, careful, this is a hot mic?
He does, yes. He's kind of whispering, this is a hot mic.
So at no point where you're capturing or recording there's not other people within, and describe the size of the studio.
Sure, it's a very small studio. It's probably a quarter the size of this courtroom.
So it's a very small room with 4 or 5 people in it where he's having this conversation.
That's correct, yes.
Nothing further.
Mr. Dorsey, where are you when these conversations are taking place?
I was in an office down the hall.
Okay, and so you had eyes on the studio the entire
I
time?
did not have eyes on the studio, no.
Okay. You could hear
Yes.
people speaking as to everything that was being said in there?
Yes.
And how were you recording again? Remind me.
I had a pair of headphones, and I had my phone, and I just hit record. I
Okay,
put the
and
headphones
so
on
it's
the phone.
essentially the studio audio that you're using.
Exactly, the live audio coming right from the studio, yes.
So it's a room. Do you know if the studio has signs that they're recording at all times? Like signage that says something like, this is a recording studio. You are
Yeah,
scenes like that.
Yes,
I've
recording
seen-
studios typically have the signs up like that. Plus, of course, he would have signed a release, so he knows he's being recorded.
Okay, got it. Anything further? Sorry, I sort of hijacked that a little bit, Mr. DeJoffman.
Not from the state.
Mr. Sam, you may cross.
Okay, Mr. Dorsey, you've never met Mr. Davis before.
We've never met. We've seen each other before.
Okay, so on the day of the recording, you made it a point to not run into Mr. Davis, fair?
Correct.
You were actually in this other room,
That's correct.
and you're there just with headphones on.
Yes.
So,
And I saw him walk by. I know
Right.
he's disagreeing with me right now. I watched him go by,
sure, and that's fine.
and he looked at me.
Okay, are you done with the answer?
Yeah, I sure am.
Okay, now, in terms of your work, I want to make sure I'm clear. Are you working as an employee of BET?
No.
Okay, what are you at that point?
I am a contract employee, work for hire, as a technical consultant for specifically this production. I'm not hired by BET. I'm hired by the production company.
The production company,
Yes, sir.
and that's Entertainment One?
Entertainment One and Creature Films, like a subsidiary of Entertainment One.
All right, and then in terms of your work with Entertainment One, that was bound with a confidential agreement, right?
Yes,
Do you have proof right now that you're no longer bound to that agreement?
I do. I have a letter from an attorney at Paramount Pictures, which owns BET, approving me sharing my information. And then I also have an email from Mark Ford, the head of Creature Films, also saying he had no objection.
Okay, so in your work with Entertainment One, what you basically do is you have your phone or whatever recording device down
Yes.
next to the monitor in which you're listening to a conversation.
Correct.
You cannot tell us who's where in your recording, correct?
Correct.
You just hear noises, right?
That's right.
Now, in terms of the actual recording itself, as the individuals sitting there, are they sitting with mics on their lapels as they're sitting there being interviewed by that person?
What you mean, the person conducting the interview, is he wearing a mic?
Is he wearing a mic, and is the person that is interviewing wearing a mic?
I don't know if the Mario Diaz, for example, is conducting the interview. I don't know if he was wearing a lapel mic, but there would be 2 mics in the room minimum. There would be a lapel mic on Keffe, and then there would be a shotgun mic over him that is kind of capturing everything else in the room.
Right, and so in terms of what you're recording, you don't know, for instance, if the cameras are on and off because you're actually just listening to sound.
That's correct.
And in terms of the interview, you understand that Wayne Higgins was in the room as well as
Yes.
Mr. Davis.
Yes, he was there for the entire first interview, and then he was like 10 minutes late to the second interview.
All right. Now, before we were listening to this, are there any moments at all where Mr. Davis is talking loudly during what you would think would be a private conversation?
Loudly. He's just using a normal indoor voice is what I would say.
Okay. And then when you say that there was this statement that this is a hot mic,
Yes,
fair to say that that was a reminder to whoever he's talking to that, hey, this should be kept private.
correct.
All right.
Yeah.
So there were times where there was an understanding, or at least an idea that what they were going to have a conversation about.
There was one time, that was the only time.
Now, after you had recorded what you did in this
Yes.
case, which is the entire thing.
Correct.
You never had his permission to record all of it, right?
I didn't need his permission
Why?
because he's there to be recorded. He's got mics on him. He has lights and a camera pointed at him. He's in a production studio. I'm officially hired on as a crew member. I'm allowed to do whatever I want.
No.
And-
Let's back up here, but make
Okay.
sure I'm clear.
Sure.
You're a crew member, but you don't own the rights to the production itself, right?
Correct.
And you don't own the rights in terms of what the camera angles are or anything along those lines.
That's correct. I could
Now-
not put this on YouTube and profit from it.
Okay, well, back up here again. I want to make sure I'm clear. Did you take that audio recording that you made and give it to either Entertainment One or any of the subsidiaries in this case?
No.
Okay, so you basically took something that you didn't have permission to take.
That's not true.
Okay, well, back up here. Tell me who you got permission from.
I didn't need permission. Do you understand? There's no permission needed for that. I'm there to do it. I made the recording because he showed up for the first interview, not ready for his interview to be conducted. So I knew it was going to be broken up into 2 days. So I said, I'm going to make a recording of this so that I can make sure we ask the correct follow-up questions when we come back. That's the only reason I made this recording.
But you're not the contract person. You don't have a contract. with
I
this.
apologize, we're way afield of the issue that the court needs to rule upon, and this sounds like cross-examination for a jury.
Oh, I'll get back into it, Jerry. I'm just saying as of right now, Judge, we have a problem with this. Thank you. And just to make sure I'm clear, you take that recording and that's the recording that you're now publishing here for this jury, right?
Publishing, no. Playing for the jury, yes. Publishing it suggests publicly. I'm not putting this out to the public.
That was a legal terminology,
Okay.
but you're playing that for the jury now.
Yes,
right?
sir.
I have no further questions.
Anything further, State? All right. In general, the attorney-client privilege under 49.095 is broken when you speak in front of a third party who's unrelated to the legal team. Here, it appears as though Mario Dorsey and there others were potentially present for the conversations. Additionally, the setting of the interview itself does not lend itself to a belief that the conversations would be privileged and or private. It's a recording studio. The purpose is there to be recorded. A release is signed so that the person can be recorded. The entire room is microphoned up. Additionally, there are microphones on the people participating in the interview. In general, this isn't a situation that would lend itself to private conversations. I think based on the testimony, they are not privileged conversations. Circling back to the issue regarding the instruction to the jury, Mr. Samft, is there anything, did you want me to reread the Tavares instruction, which I can add something related to the unrelated shooting to? That proposal for that would be this. You have heard testimony regarding drug trafficking, conspiracy, a federal conviction, gang affiliation, and an unrelated shooting.
Judge, that's not an unrelated shooting. In 2015, he lets the cops come in his house and they find a gun and I think some drugs, and that's what he goes to prison on in 2015. The shooting he's talking about is his teenage shooting that's written about in his book. So Mr. Shams was conflating the two.
Okay.
The 2015, I
So
think,
how
I
about
believe
just
is
instead of federal conviction, prior criminal convictions?
a conviction in 2015? Because that's the only one that wasn't
My
part of the
point is
motion.
saying that it was unrelated, is saying that it's unrelated to this incident.
Correct, unrelated 2015 incident.
So what's your proposal, Mr. Samft? I saw you had a piece of paper.
Yes, Your Honor, myself and the defense team worked on a Tavares instruction that says you are instructed that any testimony and or evidence introduced about any unrelated shootings and or murders is not admitted and should not be considered for propensity purposes, but instead for the purposes of motive, intent, or to establish the credibility of defendant's statements.
It's not only not to be considered for propensity, it's not to be considered for any outside thing other than those narrow exceptions that we've delineated.
Okay, that's the propensity purposes was the.
So if you're okay with that defense, you want to add or any other purpose somewhere, okay.
Yeah, you can add it where you want.
Okay, let them add that and then bring it up to me and I'll use that as my master. And we'll ultimately end up giving this instruction to the jury in their packet.
Thank you.
So that's your suggestion, and that is granted, Mr. Samft. As soon as Ms. Panduke finishes looking at it. Almost there, Mr. Dorsey.
Great.
Give us a minute.
I'm fine.
Okay.
Any testimony and or evidence introduced about too many? About take the two out, yeah. Any unrelated shootings and murders is not admitted and should not be considered or considered by you for propensity of other purposes except for the purposes of motive intent to establish the credibility of defendant's statements. Let's see if you can read it, judges. Some Benu's, some Pauline's handwriting.
God, guys. You should both be doctors here.
I know. I'll rewrite it later.
No, it's okay.
You sure?
I think I got it.
Okay. Have a little.
Okay, so this is what I'm going to read. Tell me if there's an objection. You are instructed that any testimony and or evidence introduced about any unrelated shootings and or murders is not admitted and should not be considered by you for propensity or any other purpose. It is admitted only for the purposes of motive, intent, or to establish the credibility of defendant's statements. Any objection?
No.
Perfect. All right, I can read it. So as soon as we bring the jury in, I'll apologize for being a little bit late, my fault, and then I will read them the limiting instruction and we'll get going.
Can we leave Mr. Dorsey on the stand?
Yeah, I think so.
Yeah.
All right, so as soon as that jury's ready to go, we'll go.